Thank you very much, Karina, and thank you, Elizabeth and Nella, for organizing this conference. It's a pleasure to be with you, even though it's just virtually. I will try to be relatively brief so that hopefully I can hear a little bit from the audience, especially because I'm participating online. I'm curious to hear what those in the audience think about the topic I want to share thoughts with you about, which is evidence as a form of storytelling. And I particularly want to focus on the advisory opinion proceedings that have started or that will start soon before international courts and tribunals, with a focus on Vanuatu's pursuit of an advisory opinion from the International Court of Justice. So evidence is, of course, crucial in legal proceedings from a formal legal point of view. For proving a legal point, essentially, without evidence, one cannot win a case. And I think many litigators would say that most, if not all, cases ultimately turn on the evidence. But evidence is more than that. It's also an incredibly powerful way for those who are at the front lines of climate change or those who are otherwise affected to tell their story and to gain agency and power in that way. So that's what I would like to talk about. And of course, the law very much also it can serve as a framework for the story, or can steer the story in a particular direction. And here, of course, when we talk about rights-based litigation, that is particularly important, where human rights come with a particular framing that also have evidentiary implications and implications for the kinds of stories that are being told, obviously with a focus on individuals or groups, peoples. So when it comes to the advisory opinion proceedings, let me then also tell you the story of the Vanuatu's initiative to seek an advisory opinion on climate change and human rights from the International Court of Justice. And of course, when you tell a story, you can, there are often different possible starting points and different perspectives. This particular story can be traced back to different points in time, but let me locate you to March 2015. Let me take that as a starting point, because in March 2015 in Vanuatu, as for those of you who don't know, Vanuatu is a small island state in the South Pacific, which is comprised of more than 80 small islands. It's volcanic, so it's not most islands are not low-lying, but it is a nation that is particularly vulnerable to climate impacts, particularly cyclones. And so in March 2015, a Category 5 cyclone of unprecedented strength for the Pacific hit Vanuatu and also Tuvalu, Kiribati, and the Solomon Islands, and caused a huge amount of damage. More than 11 people were killed as a direct result of the cyclone. There was further loss of life afterwards. And the damages that the nation suffered amounted to more than 67% of Vanuatu's GDP. This disaster, which Vanuatu's head of state at the time, Vanuatu's president, Lonsdale, dubbed a monster cyclone, was it occurred at 0. When global warming amounted to 0.9 degrees Celsius. And now, as you all know, we have already reached 1.2. So one can only imagine what happens, what will happen at 2 degrees or even 3 degrees of warming. The cyclones will likely be so devastating that nations like Vanuatu will be uninhabitable. And then not to mention the implications of sea level rise, coastal erosion, unpredictable weather patterns, which also affect Vanuatu, affects food security in Vanuatu and other island nations across the Pacific. Entire communities have been relocated because the areas where they lived were no longer safe. And so in sum, the impacts of climate change on Vanuatu and similarly situated states are existential. 2015 was really for Vanuatu a point in time when Vanuatu realized the extent of its vulnerability, and it was also the year at which, the Paris Climate Conference took place and under-delivered. The Paris Agreement was adopted, a major breakthrough and a victory in some senses for Pacific Island states and other climate vulnerable states like Vanuatu, because it referenced 1.5 degrees Celsius as an agreed limit on temperature rise, albeit ambiguously and alongside a 2-degree goal. But that for climate vulnerable countries, that was a victory because the more powerful states were not inclined to actually include that target at all. So its inclusion was a victory. Of course, it was also, through the COP decision, it was adopted alongside the Paris Agreement, a call for a special report from the IPCC on 1.5, which was delivered 4 years later, and really made it clear that 2 degrees as a limit is insufficiently ambitious, and that the risks would be so great that the world really must keep global temperature rise to 1.5 degrees. And so the report showed that, and it showed also the feasibility. It showed that there are pathways to keeping global temperature rise below 1.5. And these pathways were again, of course, fine-tuned, you can say, in AR6, the 6th assessment report. So all of this evidence was generated, and we have this temperature, long-term temperature goal in the Paris Agreement. But the Paris Agreement also really locked in a system of voluntary action, right, with nationally determined contributions that are, as the name says, nationally determined. So there's no common baseline and then a dividing of the efforts at the international level, but instead states decide for themselves what action they must take, and then plus these nationally determined contributions are voluntary. So it's a rather weak system, and for Vanuatu, that those two factors, first of all, experiencing how vulnerable it is, how existential these impacts are, and then on the other hand, seeing that the international climate negotiations didn't deliver sufficient protection, you can say, led to a discussion about what else could be done apart from participating in the international negotiations and collaborating with other states. And so together with a few others, I delivered advice about the options that exist under international law. And at the same time, students at the University of the South Pacific also ask themselves the question, what does international law offer us as inhabitants of small and developing states, where within our jurisdiction, so to say, are no major polluters. We ourselves are not major polluters. The causes of the problem are elsewhere. How can we use the international legal system to change this and to protect us and protect our rights? So that's for the students then really identified the option of going to the ICJ and requesting an advisory opinion rather than suing another state as the option that was most promising for a range of reasons. So it's the fact that the ICJ is the world court, the world's highest court, as the students put it. Also, that the advisory opinion proceedings are the most inclusive process that exists anywhere in the world for a legal process on climate change, given the right of all UN member states to participate in the process, and also the fact that a request would need to come from the UN General Assembly realistically, which also involves and requires the participation of all UN member states. And so that pathway was identified as the most promising one. Then the students successfully lobbied the Vanuatu government, and the Vanuatu government decided to indeed take this on and pursue this option. So that was 2019. Then a long process of capacity building had to happen in Vanuatu, both on the ground, in Port Vila, as well as and in the various missions, including New York, because of course there's a massive diplomatic campaign trying to get most of the UN membership, if not all of the UN membership, on board with this idea. Well, for Vanuatu, the ambassador, Vanuatu's ambassador to New York, had a very small team there, basically just 3 people running the mission. So the capacity there had to be built, and at the same time, a legal question had to be prepared. And that was, of course, a task that was on our plate as the legal team. We've been working on that very hard, while the government built capacity and the youth also built a global movement in support of this initiative. Well, fast forward to yesterday. Yesterday at 2 p.m. New York time was a deadline for UN member states to indicate that they would co-sponsor the UN General Assembly resolution that contains the legal question to be put to the ICJ. And that resolution itself, of course, is the product of extensive negotiations between states. So there have been a core support group, cross-regional core support group was put together to produce a first draft of the text, or work on the draft that Vanuatu initially put on the table. And that was discussed with the full UN membership through informal informals, and then feedback was again discussed within the core group, and it's the core group then that ultimately decided on the final text, which was uploaded. And yesterday was when Vanuatu had set the deadline for other UN member states to come forward with indications of co-sponsorship. And I should mention that states that still want to sign on still can sign on, because co-sponsorship is possible up until the moment of adoption, basically. But yesterday's deadline was to make sure that those who are really keen to be to be mentioned, let's say, will also be mentioned by name on the final draft text that will be shared for adoption. So it is that final draft text now exists, and very happy to report that 105 UN member states have indicated that they co-sponsor the resolution. And given that for adoption of a UNGA resolution, a simple majority of states, UN member states, is required, it seems that the likelihood of this resolution being adopted and the requests being passed on to the ICJ registrar are very, very high. It seems that something very strange would need to happen for this now to go off track and not be adopted. So that's a bit of a breakthrough. So that is the story of the first part of the story of this initiative. But of course, now a really interesting question is, how about the legal proceedings before the courts in The Hague? How about the storytelling that could happen in The Hague? And in other words, what kinds of evidence would UN member states be able to present to the court in writing, also perhaps during the oral proceedings, during the hearings, and what would be the significance of those stories? So, of course, the stories to be told or the evidence to be submitted needs to fit within a legal framework. And so to understand the role of evidence in these proceedings, we need to look at the legal question that will likely be posed to the court. And so I think many of you will probably have seen the draft question that is contained in the resolution. It's also, for those of you who are not following the campaign very closely, it's publicly accessible also on Vanuatu's campaign website, which is vanuatuicj.com. So if you go to that website and then vanuatuicj.com/resolution, that will bring you to the text of the draft resolution as it stands and as it was uploaded. And so you'll see that one thing to point out actually here is that one thing to avoid, of course, in this kind of process is a trial over the science. That would not be very helpful if the ICJ would get drawn into an assessment of whether climate change is man-made, for example. And so to avoid that, to prevent that from happening, the drafters of the text have already included some very significant statements about the science, which were very deliberately drawn from the summaries from policymakers of IPCC reports, so that these statements reflect not only the best available scientific evidence, but also evidence that is agreed, as you know, by governments as part of the intergovernmental part of the IPCC process. The summaries for policymakers are negotiated, as you know, line by line. So this really reflects also a consensus amongst states. So you'll see here in the preambular paragraphs 7 and 8 that the UN General Assembly in this resolution notes with profound alarm that emissions of greenhouse gases continue to rise, despite the fact that all countries, in particular developing countries, are vulnerable to the adverse effects of climate change and have significant capacity constraints, etc., etc. And then also noting with utmost concern the scientific consensus expressed in the ADA and the reports of the IPCC, including that anthropogenic emissions of greenhouse gases are unequivocally the dominant cause of the global warming observed since the mid-20th century. That human-induced climate change, including more frequent and intense extreme events, has caused widespread adverse impacts and related losses and damages to nature and people beyond natural climate variability, and that across sectors and regions, the most vulnerable people and systems are observed to be disproportionately affected. And so here is already the science basically on causation, all the way from the source of climate change, anthropogenic emissions, through to the impacts, which are losses and damages to nature and people beyond natural climate variability. So that should help in terms of also framing as well as proving, as well as telling the story of climate change, what it is and how it impacts people and their rights. And so now the legal question, you'll have seen that the legal question has two components. So the first part of the question asks about the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations. So to understand what those obligations are, science is really critical, because of course really the added value of an advisory opinion is that it clarifies states' obligations, and it puts kind of flesh on the bones of the law as it is, and really gives states insight into what it is exactly that international law requires them to do. So here, of course, the IPCC, the evidence about the causes of climate change is very important. But building on that, it will be important for evidence to be submitted that also shows the courts the pathways for keeping temperature rise below 1.5 degrees, and to provide insight in what it is that states can do, realistically can do and need to do, to show that they act with due diligence. Because we know that these obligations or due diligence exist. It will be very useful for the courts to confirm that, but it will be even more useful if the court then also tells what that really involves, and for the court to be able to articulate that, the evidence will be really critical. And then of course there is the evidence on impact, evidence to show how human rights are already affected by climate change and will be further impacted in different scenarios. So there again, there will be a very important storytelling component here, where those affected can actually tell their story, either through a narrative, but also possibly by coming to The Hague and telling the court in person how climate change already affects them and their rights. And then finally, the question about legal consequences. That is the second component of the question. So the court is not only asked about states' obligations, but also about the legal consequences under these obligations for states where they have caused significant harm to the climate system and other parts of the environment. And then here there is an interstate dimension to that question. So the first sub-question asks the court to specify obligations or legal consequences with respect to states, in particular SIDS, that are particularly vulnerable, injured, or specifically affected by the adverse effects of climate change. And then secondly, peoples and individuals of the present and future generations who are affected by the adverse effects of climate change. And again, this is about, in part, it's of course about cessation, about ceasing what the ICJ understands to be the wrongful conduct, and it's about reparations, so wiping out the consequences of internationally wrongful acts. And here again, the storytelling component is incredibly important, because the court will need to understand how rights that have been violated can be restored or when there's a threat of a violation, how violations can be prevented, but also if a violation nonetheless occurs, what can be done to restore rights. And of course, we're talking about rights. So this is not about paying a sum of money. It's about restoring dignity, making sure that people's means of subsistence, self-determination, culture, etc., can really be protected over time as the climate changes. And so this story is also a story that will be a historic one. And it is one that I hope will be told in a very inclusive way by a very diverse range of voices and amplified far beyond the legal proceedings. So I'll leave it at this. I hope that I'll have time to hear a little bit of feedback or questions, and otherwise as part of the Q&A.
We have exactly 1 minute. So thank you very much, Margaretha. That was really really interesting. I'm sure there are questions in the audience. Thank you very much. I'm sure there are questions. In the 1 minute that we have, I would take just one question. If you could please use your microphone, because I'm not sure that the people online can hear you otherwise. Yes.
Okay.
And if you could introduce yourself, Natalia.
Yeah, sure. Thank you very much. Thank you, Margaretha, for this presentation and the story about the storytelling. Thank you. Just quick question. Do you think it's a good thing that we will soon have 3 requests for advice or opinion? Assuming that yours will pass, that there was one before the Inter-American Court of Human Rights, there is one before the International Tribunal of the Law of the Sea, and now this one coming to the Court of Justice. Is it good, in your opinion?
Yes, very good. If I have to answer in 2 words, then it's very good. It's very helpful because, well, there are many different stories to be told, and each of these judicial bodies plays a different role in the international legal system. So ICLAS, as you know, it's really very good in dealing with scientific evidence, and of course obligations that exist for states under the law of the sea are very specific obligations that require focused treatment by a specialized tribunal. So that's a very important initiative of Palau and Palau, Antigua, Tuvalu, and the states that have joined, which include Vanuatu. And then, well, I've talked about the ICJ proceeding, but the Inter-American Court of Human Rights also has a very important role to play in clarifying states' obligations, and of course with a particular focus on the Americas. The set of questions that is posed to the Inter-American Court, of course, it's quite a long list of questions, and they're broad and very important questions. There will be some overlap with the questions that are asked that will go to the ICJ, but it's some overlap, but certainly there are areas that the Inter-American Court is asked to cover that the ICJ is not specifically asked to cover. And the most important point, perhaps, in response to this is interjudicial dialogue. So most, if not all, international courts and tribunals these today value interjudicial dialogue. We see it already happening, of course, at the domestic level and the regional level, but international courts and tribunals tend to build on each other's work. And we've seen that, I think, in one example that I really like is how the Committee on the Rights of the Child built on the Inter-American Court's advisory opinion on human rights and the environment in dealing with the complex question of states' extraterritorial obligation or the reach of jurisdiction. Did that in a very, I think, elegant, helpful way, where you really that really demonstrates how the interpretations of one or the practice of one body can help another body to grapple with a similar question and build on it.